Ever sign a lease and think, man, I should really read the fine print?
Well, today's deep dive is all about why that impulse is right on the money, especially when it comes to property.
We're tackling a chapter from a legal textbook on property ownership. And let me tell you, it's way more interesting and important than it sounds.
It's about uncovering the hidden layers beneath something most people think is pretty straightforward owning stuff.
Exactly. We assume it's as simple as it's mine.
But the reality is, there are so many ways that ownership can play out, especially when multiple people are involved.
Take concurrent ownership, for example.
Concurrent ownership. Okay, you're using the legal jargon already. Break it down for me. Simply put, it means more than one person has the right to control the same property at the same time.
Think vacation homes, inherited land, even a joint bank account. Got it. So, like, my sister and I inherited our grandma's beach house. We're both on the deed, that kind of thing.
You're living a real-world example. That sounds like tenancy in common, where each of you owns a distinct share.
You can sell your share, mortgage it, even leave it to someone else in your will without the other owner's permission.
Oh, okay.
That makes sense. So it's like we each have a slice of the beach house pie.
But what about those situations where, say, a married couple owns a house? It's not like they're slicing things up individually. That's where things get really interesting. For married couples, some states have something called tenancy by the entirety.
Now, this can be a game changer, especially in situations like debt or divorce.
Oh, how so? Because in a tenancy by the entirety, creditors of one spouse usually can't touch the property. It's designed to protect the family home.
Hold on, that blows my mind. So you're telling me if one spouse gets into financial trouble, the house is totally safe?
It can be, yes. It's like a legal fortress around the family home.
This type of ownership recognizes the marriage as an economic partnership, which has huge implications for things like debt and even inheritance. Wow, I bet that leads to some wild situations.
You have no idea. Our textbook gave this crazy example. A couple owned their home as tenants by the entirety, and the husband had some serious tax problems.
The government tried to seize his half of the house to pay his debt. No way did they succeed. That seems wildly unfair to the other spouse.
Right. Well, the Supreme Court actually sided with the government, but here's the catch. They said the husband DD have an individual interest in the house, like the right to live there and get income from it.
Okay, so he couldn't sell it out from under his wife, but the government could still stake a claim. What a legal loophole.
Exactly. And that highlights just how complex these seemingly simple ownership structures can be.
And we haven't even gotten to those timeshare agreements yet.
There's another layer. We've been focusing on fairly straightforward scenarios with individuals owning property, but what happens when it's owned by an entity like a corporation?
That's where the whole game changes. All right, before we go there, let's back up a second. We were talking about concurrent ownership before, and I thought of another example.
What about when couples buy a house but aren't married? Or friends who go in on a vacation cabin together? You're right, we should unpack that. It's not always as straightforward as marriage or family ties.
In those cases, they would most likely be considered joint tenants, which comes with its own set of rules and potential pitfalls. Pitfalls? Like what? Don't leave me hanging.
Joint tenancy has this thing called the right of survivorship.
Okay, right of survivorship.
Which can be a huge deal, especially if you're not expecting it.
Sounds intimidating.
In simplest terms, it means if one joint tenant kicks the bucket,
okay,
their share of the property automatically goes to the surviving owner.
Wait, really?
Not to their heirs.
So let's say I buy that cabin with my friend, and she puts in her will that her share goes to her brother.
Right.
If something happens to her,
yep,
her brother gets nothing.
You got it.
Wow.
The right of survivorship trumps any will provisions. It's designed to keep ownership within that joint arrangement.
Wow. That's a pretty powerful, right?
It is.
I could see how that would be appealing in some situations, like for married couples who want to ensure the surviving spouse inherits everything.
Right.
But for friends going in on a vacation cabin, that could get messy.
Absolutely.
Yeah.
And that's why even with friends or family, it's crucial to have clear legal agreements in place.
Yeah, don't just rely on a handshake and good intentions.
Don't rely on good intentions, exactly.
Get everything in writing. So we've talked about tenancy in common and joint tenancy.
Right.
Are there any other ways this whole multiple owner thing can shake out?
Well, our Legal Eagle textbook also dives into some seriously hairy situations that pop up with joint tenancy.
Okay. Especially when you throw leases and mortgages into the mix.
Okay, spill the tea.
Let's say
this sounds juicy.
Two friends, we'll call them Bob and Alice,
okay,
own that vacation cabin as joint tenants.
Mm-hmm.
Bob decides he'd rather have the cash flow.
Okay.
So he leases out his half to a third party. Let's call him Tom.
Okay, seems straightforward enough.
Right.
What's the problem?
The legal headache hits when Bob dies.
Uh-oh.
Does that lease simply vanish into thin air because of the right of survivorship, leaving Tom out in the cold?
Right.
Or does Tom still have a legitimate claim to lease that portion of the property, even though the ownership structure has changed?
Wow. Yeah, I see how that would throw a wrench into things.
Right.
So, what's the answer?
Believe it or not, legal minds are actually divided on this one.
No way. Some courts have ruled in favor of the surviving joint tenant, essentially saying, tough luck, the lease died with the owner.
Wow.
But other courts have upheld the lease, recognizing the tenant's rights.
Talk about a legal gray area. So if you're thinking about entering into a joint tenancy, what's the best way to avoid this kind of nightmare scenario?
Clear communication and ironclad legal agreements are key.
Of course, yeah.
Spell out exactly what happens to leases or mortgages if one owner dies.
Solid advice. Don't rely on assumptions, folks. Now, earlier, you hinted at this other world of property ownership where it's not a person who owns something, but an entity.
Right.
What did you mean by that?
It's the wild world of entity property, and it's more common than you might think.
Okay.
Think about the businesses you interact with every day.
Okay.
Most aren't owned by one person holding all the cards. They're corporations, LLCs, trusts.
Okay.
Even those sprawling condo complexes are often governed by homeowners associations.
Okay, I think I'm starting to see the picture here. So instead of me owning a shop outright,
Right.
it's owned by, say, Bob's Bakery, Inc.
Right.
And then I own part of Bob's Bakery, Inc.
Exactly. The entity, Bob's Bakery, Inc., in your example, actually holds the legal title to the property.
Okay.
You, as the business owner, might own shares in the corporation, but the corporation itself is the one with the ownership rights on paper.
Right.
And that distinction between who owns the entity and who controls the property is really important.
So it's like a legal separation between the actual property and the people who benefit from it.
Exactly.
What are the implications of that? I imagine it gets complicated.
You're right to be cautious.
Yeah.
Our textbook dives into this with a fascinating excerpt from The Modern Corporation and Private Property by Burl and Means.
Okay.
They argue that this separation of ownership and control is a fundamental shift in how property works.
Wow.
They even use the metaphor of the atom of property being split.
Oh, splitting the atom. That sounds dramatic. What does that even mean in this context?
It's their way of highlighting how the traditional connection between owning and controlling property gets fractured.
Okay.
Think about shareholders in a massive corporation who
Right.
technically own the company,
Right.
which might include factories, office buildings, all sorts of assets,
Mm-hmm.
but they don't directly manage those assets, do they?
Right. They elect a board of directors to make those decisions.
Exactly.
Yeah.
And that's where things can get sticky. The board of directors and the company's executives have a lot of power,
Right.
and the shareholders, the actual owners, often have very little control over how the company's property is used or managed.
So what's to stop those managers from going rogue? It sounds like there's potential for abuse.
You've hit on one of the central tensions of entity property, the principal agent problem.
Yeah.
It's like sending your kid to the store with a $20 bill
Right.
and hoping they come back with the groceries you asked for.
And not just a giant bag of candy.
Exactly.
I get it.
And in the case of corporations, the stakes are much higher than a candy bar.
Right.
You've got shareholders entrusting their money and essentially their piece of the property to managers,
Right.
hoping they'll act in their best interests.
Okay, so how do we prevent these managers from going on a spending spree with the company credit card, so to speak?
Well, in theory, there are mechanisms in place to keep things in check.
Okay.
Corporate law establishes fiduciary duties for officers and directors,
Right.
which means they're legally obligated to act in the best interests of the shareholders.
So they have a legal responsibility to be good stewards of the company's assets, including its property.
Exactly. It's like a built-in accountability system.
Yeah.
But as you can imagine, enforcing those duties can be a whole other can of worms.
Right.
And that's where things can get really interesting.
This is reminding me a bit of that tenancy by the entirety situation.
Yeah.
Sounds like there are loopholes and exceptions galore in the legal world of property ownership.
You said it. And to illustrate just how complicated things can get, let's dive into one specific type of entity property. Corporations.
Okay, so corporations. Big companies, lots of assets, even more shareholders. Where do things get messy?
Well, a classic example is when shareholders feel like the people in charge, those directors, aren't acting in their best interests.
Right.
Our Picks book actually had a case about this, the Ford Motor Company.
Ford.
Yeah.
As in the car company.
All right.
Tell me more.
Shareholders were fuming because the Ford board was accused of making some questionable calls.
Like what?
Like, they allegedly knew about a safety issue with one of their car parts that was causing injuries, but didn't do anything about it.
Yikes. That's a PR nightmare waiting to happen.
It gets worse. They also made a massive purchase of a precious metal called palladium, which they ended up having to write off for a loss of, get this, $1 billion.
$1 billion.
Yeah.
Ouch. You'd think that would have the shareholders up in arms.
Right.
So what happened?
Well,
did the board get punished for those decisions?
What's the kicker? They didn't.
What?
The court actually sided with the board, saying they were protected by something called the business judgment rule.
Okay.
Essentially, this rule gives directors a lot of leeway as long as they can show they were acting in good faith and made a reasonable effort to be informed.
Wait, so even though their decisions potentially harmed people and cost the company a fortune, they were off the hook?
Yep.
Just because they supposedly didn't intend to mess up.
Welcome to the complexities of corporate law. The idea is that courts don't want to be in the business of second-guessing every business decision made by a board of directors.
Right.
But it definitely highlights that tension between protecting shareholders and giving directors the space to make tough calls.
I bet there were some shareholders out there who wish the court had gotten a bit more involved. But this whole thing with Ford really underscores how this separation of ownership and control, this split atom of property, can get messy.
Yeah.
Is there another way to look at this, though? You mentioned something about a contractual theory earlier.
You're right. There's always another side to the story.
Okay.
The contractual theory basically says that the relationship between shareholders and managers is, at its core, governed by contracts. So shareholders buy stock, which is essentially a contract with the company, and managers are hired under contracts that outline their responsibilities.
So it's like a giant web of agreements, and everyone's supposed to just stick to the terms.
Pretty much.
But what happens when those agreements aren't enough? Like in the Ford case.
That's the million-dollar question. Proponents of the contractual theory, like Professor Butler, whose work is mentioned in the textbook, argue that the market itself is a powerful disciplinarian.
Oh, yeah.
If managers consistently make bad decisions, the company's stock price will plummet, and they'll either get the boot or be forced to change their ways.
It's like a corporate survival of the fittest.
Exactly.
So we've got these two competing ideas about how entity properties, specifically corporations, should function.
Right.
On one hand, we've got legal duties and regulations trying to keep things in check.
Yeah.
And on the other hand, we've got the market forces of capitalism, with the idea that bad decisions will naturally lead to consequences.
It's a balancing act for sure, and there's no easy answer.
Definitely gives you a lot to think about the next time you're browsing the stock market. But we've only scratched the surface of entity property.
Right.
We talked about corporations, but what about those other entities you mentioned earlier? LLCs, trusts, HOAs.
Right.
How do those work in the context of property ownership?
You're right. There's a whole universe of entity types out there. Take LLCs or limited liability companies, for example. They're like a hybrid between partnerships and corporations, offering a lot of flexibility for small business owners.
Okay.
The key feature of an LLC is, you guessed it, limited liability.
So if the business goes belly up, the owner's personal assets are protected. That's a pretty sweet deal.
Exactly. It shields the owners from personal responsibility for the debts and obligations of the LLC, including anything related to property owned by the LLC.
Smart move for anyone starting a business. What about trusts? Those always seemed kind of mysterious to me.
Trusts are fascinating because they're incredibly versatile.
Okay.
They're often used in estate planning to manage assets and make sure they're distributed according to the wishes of the person setting up the trust.
So instead of leaving everything to your heirs directly,
Right.
you create a trust that holds the property,
Right.
and the trust follows your instructions.
Precisely. And trusts can hold all kinds of property, houses, investments, even businesses.
Okay.
And then there are those real estate investment trusts, or REITs. Ever heard of those?
Actually, yes. I dabbled in REIT investing a while back. They basically own and manage big properties like shopping malls and apartment buildings.
You got it. And because they're publicly traded, investors can buy shares in these massive real estate portfolios without having to go out and buy an entire shopping mall themselves.
Talk about diversifying your portfolio. It's amazing how these entities make it possible for people to invest in property on a scale they never could individually.
It's the evolution of ownership. And let's not forget those HOAs, homeowners associations.
Whoa. Yeah.
They might not be as glamorous as corporations or trusts, but they wield a surprising amount of power.
Oh, tell me about it. I have friends who live in condo complexes with HOAs that have rules for everything from what color you can paint your front door to where you can park your bike.
It's the price you pay for communal living. But in essence, the HOA is acting as a mini government, enforcing rules and regulations that impact how owners can use and enjoy their own property.
Right.
It's a prime example of how entity property is woven into the fabric of our daily lives, even on a smaller scale.
It makes you realize that property ownership isn't just about holding a deed to a piece of land or a building.
Right.
It's about navigating this complex web of rights, responsibilities, and relationships.
Exactly.
Whether those relationships are with family members, business partners, or even a faceless corporation.
Well said. And it's a web that's constantly evolving as our legal and economic systems adapt to new challenges and innovations.
This deep dive has definitely given me a whole new perspective on something I took for granted. I'll never look at a lease agreement, a corporate logo, or even my neighbor's meticulously manicured lawn the same way again.
And that's the beauty of digging deeper, isn't it?
Right.
Uncovering the hidden layers beneath the surface of something we encounter every day.
Absolutely. Well, folks, there you have it. A whirlwind tour through the fascinating and often perplexing world of property ownership. From the ins and outs of concurrent ownership to the rise of entity property, we've explored how this fundamental concept shapes our lives in ways we might never have imagined. Until next time, keep those minds curious, and remember, there's always more to uncover when it comes to the stuff we think we own.